Section 437 CrPC empowers a police officer in charge of a police station to grant bail to a person who is accused of a non-bailable offence. This power, however, is severely restricted. A police officer cannot grant bail to a person who is accused of a non-bailable offence and the offence is such for which the punishment is either death or life imprisonment. He also cannot grant bail to a person who had been previously convicted of a specified offence. Section 437 also empowers the court of a magistrate to grant bail to a person accused of a non-bailable offence. That power is also restricted. A magistrate cannot grant bail to an accused who is suspected of having committed an offence which is punishable with death or life imprisonment if the accused is a male above 16 years of age and is not infirm and is not sick. In such a situation, there is an absolute bar to the court of the magistrate to grant bail. Such restrictions are not applicable to a court of sessions and to a high court, which courts are also empowered under section 439 to grant bail. Section 439 subsection 1 empowers a high court or court of session to direct that any person accused of any offence be released on bail if he is in custody. There is no restriction here of the kind of person or of the nature of offence. Any person accused of any offence may be directed to be released on bail. If the offence is of the nature specified in section 437(3), then the court may impose any condition which it considers necessary for the purposes mentioned there. What are the offences which are specified in 437(3)? Offences which are punishable with imprisonment of more than 7 years, and offences specified in Chapter 6, Chapter 16 and Chapter 17 of the Indian Penal Code. If bail is to be granted in respect of such offences, then the High Court or the Court of Sessions, as the case may be, may impose conditions which are specified in section 437(3). It is also to be observed here that this provision 439(1) is applicable when a bail has been refused by a magistrate, when a bail has been refused by a police officer. It is also applicable when the accused chooses directly to come to the Court of Session or to the High Court. There is no restriction as to the stage at which provisions of section 439 can be invoked. It is further provided that a High Court or Court of Session may direct that any condition imposed by a magistrate when releasing any person on bail may be set aside or modified. If a person is aggrieved with the condition imposed by the magistrate under section 437, then he can approach the Court of Session or High Court for a relief. A proviso was inserted in 2018 in section 439(1), and this proviso says that the High Court or Court of Session shall give a notice of the application of bail to the public prosecutor if the offence is triable under the following 4 sections: 376(3), 376(ab), 376(da), 376(db). These are offences of rape and gang rape where the victim is a woman under 16 years of age or under 12 years of age. If a person accused of any of these offences approaches the High Court or Court of Session for a bail, for a release on bail, then the High Court or Court of Session is required to give notice of this application to the public prosecutor. By implication, it means that no notice need be given to the public prosecutor in respect of other offences. The High Court or Court of Session can grant bail to a person accused of any other offence without notice to the public prosecutor. A notice is mandatory only in respect of these four offences.